Welcome to EUPrivacyForAll, Session 23 on GDPR, Article 47, Binding Corporate Rules. Article 43 on transfers by way of binding corporate rules was finally retitled Binding Corporate Rules, and it is Article 47. It lays down that the competent supervisory authority shall approve binding corporate rules in accordance with the consistency mechanism set in Article 63 of this regulation, provided that they are legally binding and apply to and are enforced by every member concerned of the group of undertakings or group of enterprises engaged in a joint economic activity, expressly confer enforceable rights on data subjects, and fulfill the requirements laid down in the following paragraph. The binding corporate rules shall specify at least the structure and contact details of the group of undertakings or group of enterprises engaged in a joint economic activity, the data transfers or set of transfers, their legally binding nature, both internally and externally, the application of the general data protection principles and the requirements in respect of onward transfers to bodies not bound by the binding corporate rules, the rights of data subjects, and notably the right to obtain redress and, where appropriate, compensation for a breach of the BCR, the acceptance by the controller or processor established on the territory of a member state of liability, that is to say, a controller or processor shall be responsible and liable unless it would be exempted from that liability, proving that that member is not responsible for the event giving rise to the damage. How the information on the binding corporate rules will be made available, and the tasks of any data protection officer. The complaint procedures, the mechanisms within the group of undertakings or group of enterprises engaged in a joint economic activity for ensuring the verification of compliance, including audits and corrective actions, the mechanisms for reporting and recording changes, the cooperation mechanism with the supervisory authority, the mechanisms for reporting to the competent supervisory authority any legal requirements to which a member of the group of undertakings is subject in a third country, which are likely to have a substantial adverse effect on the guarantees provided by the BCRs, the appropriate data protection training to personnel having permanent or regular access to personal data. The Commission may specify the format and procedures for the exchange of information between controllers, processors, and DPAs. In Recital 110, it is made clear that all BCRs shall include essential principles and enforceable rights to ensure appropriate safeguards for the transfers. Article 420 of the GDPR provides the definition of BCRs, that is to say, personal data protection policies adhered to by a controller or a processor. In Article 46(2)(a), BCRs are defined as constituting appropriate safeguards without requiring any specific authorization from a supervisory authority. In Article 57(1)(s), each supervisory authority shall, on its territory, approve BCRs. Article 58(3)(g) lays down that each supervisory authority shall have the powers to advise and approve BCRs. Article 64(1)(f) on EDPB reminds that the competent supervisory authority shall communicate the draft decision to the EDPB when it aims at approving BCRs. And finally, in Article 71, the EDPB is supposed to advise the Commission on the format and procedures for the exchange of information between controllers, processors, and supervisory authorities for binding corporate rules, and issue guidelines, recommendations, and best practices regarding data transfers based on binding corporate rules. The directive did not provide any framing of binding corporate rules, but a full set of provisions were provided by Working Party 29 opinions on the topic. What should accountable data controllers and processors get prepared for? First, they should be ensuring that the BCRs are deployed, that is to say, they are a legally binding and enforceable instrument between public authorities. They expressly confer enforceable rights on data subjects. They specify at least the structure and contact details, the set of transfers, their binding nature, the data protection principles applying, data subjects' rights, liability within the group, information on the BCRs, the tasks of the data protection officer, complaints handling, mechanisms for verification of compliance, mechanisms for reporting changes, and cooperation mechanisms with data protection authorities, that is to say, the competent supervisory authorities, and the information on any non-EU legal provision having substantial adverse effect, potentially, on the guarantees provided by the BCRs. The appropriate data protection training is also to be specified. Binding corporate rules do not require prior authorization, but shall be approved by national data protection authorities. And BCRs are communicated by those authorities to the EDPB, the European Data Protection Board. So the question now are about the mutual recognition EU-wide. Will all EU members contribute to the definition of BCRs and apply those? Will Working Party 29 guidance know a significant evolution regarding BCRs? And what will be the upcoming EDPB statement on enforcement of BCRs?